more at ease, this being my first time chairing a virtual session. So I want to welcome everyone. Thank you for coming out. Thank you to our presenters. And I guess without further ado, we can get started. It's about 15 minutes per presentation, and I will give a little thumbs up when we are at the 2-minute mark, just to give presenters that signal. And then that will leave us about a half an hour for questions and discussion. So I'd like to welcome you, and if as you present, maybe give us a brief introduction of who you are and maybe where you are geographically, that would be great. So I'll turn it over to Adelle for the first session.
Okay, well, good morning or good afternoon. My name is Adelle Blackett. I'm at McGill University. And thanks for the initiative of this panel. I think it's an important opening. This presentation that I'm going to give might not have been the presentation I thought I would give when I submitted in the fall. This is a moment in which the depth of white supremacy and its murderous effects, what some have referred to, Saidiya Hartman in particular, as the afterlives of slavery and settler colonialism, they're finally being reckoned with. And that is increasingly deeply understood, that these afterlives are firmly embodied in Indigenous peoples and in the African descendants of the transatlantic slave trade. But grappling with the meaning of decolonization in labor law is too often seen as too many steps removed. My argument today is that we must confront the ways in which our field has carried forth a legacy of dispossession of Indigenous peoples and of peoples who are the African descendants of slavery. While the Truth and Reconciliation Commission in Canada has forced many to grapple with the ongoing nature of settler colonialism, I wish to suggest today that the reckoning with slavery is far less developed and yet urgent and overdue. I would commend to you, as one example of coming to terms with this reckoning, the formidable Dalhousie University report of the Task Force on Slavery, which, among other laudable features, makes a connection that I would want to see more of in our disciplines, in that it weaves together the relationship between slavery, labor expendability, and labor market segmentation, dispossession on the basis of race. You will already gather from the variety of sources I've already referred to in my opening comments that there are many ways to have this conversation. I've tended to pursue an historical lens. I frankly think an historical lens is unavoidable in these discussions, and we should be wary of reasoning only from what we see in the present effects, rather than looking deeply for causes. But even within an historical approach, there are many potential lenses. And so the lens I'm going to choose won't surprise you if you know my own research, but it might not have been where you might have thought I would be going. I want to take you to the ILO, the International Labor Organization that was founded in 1919 and that has as its mandate social justice as the basis for universal peace. It's well known that the ILO is at the center of the early origins of the notion of indigeneity as a legal concept. And that concept initially emerged as fraught, very deeply ensconced in a colonial, of course, vision of the world of work, and that vision applied to then most colonized people in Africa, Asia, and Latin America. But as much of the slippage in the archives suggest, the notion, of course, was incredibly deeply linked to the notion of race. And so racialized peoples who were not colonized were still inscribed in this language. So that history is reasonably well known and effectively chronicled in several important books that have been written about indigeneity and international law. It's less well known that around 1923, there was diplomatic wrangling between the soon-to-be beleaguered League of Nations and the ILO. The ILO wanted to be charged with the mandate to investigate and set standards on slavery, seeing it as in deep continuity with our understanding of labor law. Its constituencies, in particular dimensions of the labor movement and some civil society organizations, also reached out to ask the ILO to take up this work in a manner that would seem to be more responsive than that adopted by the League of Nations. But the matter was already in the League's hands, and it chose cooperation on its own terms. And in its fourth assembly, held in 1923, it decided to form a committee of experts with the Permanent Mandates Commission to study the matter of slavery with a view of elaborating a convention. And ultimately, there would be experts in colonial administration who would do this. The ILO was invited only to communicate one person. And although Albert Thomas, the first Director General, responded graciously, there was clearly a lament. The understanding was that the ILO had the jurisdictional space, but this would come later as it addressed forced labor and ultimately took responsibility for the theme of native labor. But would situating the work on slavery within the ILO have been likely to be more attentive to the ways in which slavery and settler colonialism are deeply intertwined? I would suggest that the genesis and ultimate conduct of the investigations and standard setting on so-called native labor suggests that maybe not. For there's a parallel history. A little earlier, in 1921, the ILO's Director General, again Albert Thomas, exchanged correspondence with leading Pan-Africanists. They called on the ILO to address the question of indigenous labor in the world, including that of African descendants of the transatlantic slave trade. These included W.B. Du Bois, the first African-American to earn a PhD from Harvard University, who studied in Germany with Max Weber, and whose rightful place as a father of US sociology was largely overlooked. He wrote poignantly about labor relations, in particular in the United States, and the ways in which race is used to divide any meaningful understanding of the working class. It also included Gratien Candace, a politician of African descent from Guadeloupe, who served in the French Chamber of Deputies from 1912 to 1942. And Thomas wrote to the ILO, Thomas wrote to Candace and to Du Bois and told them that he considered the descendants of transatlantic slave trades to be the indigenous peoples who the ILO felt a responsibility to study. In his letter, Candace acknowledged that the ILO intervention on the matter of indigeneity was, however, complicated by les diverses souverainetés nationales, the multiple questions surrounding sovereignty. But he added that the ILO was not without means of acting, and he specifically linked the creation of a section on indigenous labor at the ILO to the resolution of the Pan-African Congress, which had held a meeting in Paris in August 1921, and which had unanimously called on the ILO to institute a section charged with the protection and defense of indigenous workers. An ILO official was to be responsible for following the conditions of Indigenous labor. And this, according to Thomas, was notably something that he felt should be manned, and I use that word deliberately, by a Black person. And perhaps even more importantly, Albert Thomas opined in an apparent reflection on W.B. Du Bois's well-known affirmation that the question of the 20th century is the question of the colored line, that, and I quote, he considers that there will be no true protection of labor if we do not concern ourselves with the conditions of Black labor. And I understand that to be a broad definition of what he meant by Black. But you will forgive me for wondering what the course of history would have been like if Du Bois's gently penned offer to the ILO to consider his candidacy to head this unit had actually made it to the ILO Director General. But let's fast forward to, actually, so I was going to take you through a short discussion of the ILO at 50, when the ILO won its Nobel Prize, and when there was a degree of self-reflection, of introspection about what the ILO had not managed to do about these issues, that suggested an abiding understanding of the critical nature of dealing with historic dispossession to the broader cause of labor and labor law, labor standard setting, and what then Director General David Morse referred to as the infrastructure for peace. There was, of course, this was the end of the 1960s, decolonization in full swing, the civil rights movement in the United States and reverberating around the world, very actively alive. And the ILO could not but acknowledge the depths of the racial divide, but it went so far as to acknowledge further the extent to which the ILO, by exporting a particular model of labor and industrial relations, might well simply have been recreating the kind of divides that we needed to challenge. So this is 1969. Fast forward to now. The ILO celebrated its centenary. It issued a centenary declaration, hardly a model of concision, clearly a matter of deep negotiation amongst people who are having real difficulty with tripartism. But that declaration makes absolutely no mention of race. In the pandemic, we know that COVID-19 disparities are deeply racialized. Indigenous communities, Black communities are deeply experiencing this pandemic, and the segmentation on the basis of race as a labor market matter cannot be denied. And yet the ILO's advice on COVID-19, much of it very cogent, makes no mention of race. The silence that we're experiencing, therefore, is an aberration from the moments of lucidity in the ILO's past around why it is essential to address dispossession, to be able to speak to the issue of social justice as a vector of peace, to be able to rethink labor law models in a way that fosters emancipation. So there's so much more, of course, to say, so much more I want to say about why we need to engage with racial capitalism, why we need to, in our analyses of the work that we're doing, take on board this lens, not as an add-on, but as part of understanding the construction of a labor law that reaches what might have been thought of as the margins, but are central to any attempt to come to a place where we can actually be speaking confidently about free labor. So I'll stop there. Thank you very much.
Great. Thank you very much, Adelle. My internet connection cut out for a moment, but I apologize for that. Thank you for your presentation. So if anyone has questions or comments, please note those in the chat box. You may have to retype them because I had to restart my Zoom. But let's move on to the next session. Béatrice, if you'd like to take over from here.
Thank you. I will share my screen. Okay, so hi, I'm a master student in UQAM in law, in labor law, and I'm in Montreal. So the objective of my master's project is to document how Indigenous workers relate to labor law. When I finished transcribing my interviews, I realized that what the workers told me did not necessarily refer to their indigeneity, but rather to their job, to the specific working conditions of the trade in which they work. What were my expectations of my interviews with Indigenous workers? At first, their concerns seemed largely similar to those of non-Indigenous workers in the same trade. To go beyond that first impression, I compared how Indigenous and non-Indigenous workers viewed their working conditions in labor law in the silvicultural sector of forestry. To do so, I drew on my own interviews and on data previously gathered as part of a larger research program involving non-Indigenous silvicultural workers conducted by my supervisor, Leah, in collaboration with my co-supervisor, Hugo Asselin, which I thank for the work on this presentation. Today, I will speak about brush cutters, a specific group of silvicultural workers. What you need to know is that in Quebec, to control the competing vegetation in plantations and other regenerating forest stands, it is forbidden to use chemicals such as glyphosate, as is used in other Canadian provinces. Rather, competition is removed mechanically, that is, with a saw like this one. Brush cutters are paid on a production basis, therefore depending on the area cleared daily, taking into account site conditions. Workers must deal with 4 main constraints. 1, the seasonality of the work. 2, the weather and terrain conditions. 3, the remoteness of brush cutting activities, which implies 4, significant mobility for the workers. It is a very physically demanding job and is considered to present a high to extreme risk of accidents. For my master's, I worked with 2 Anishinabeg communities, one of the 11 Indigenous peoples in Quebec, mostly located in the Abitibi-Témiscamingue region. The community of Kitchissakik, located in a forest setting, and the community of Picogan, which is near an urban center. In both cases, the businesses I worked with were cooperatives owned by Indigenous interests. I will compare the results from Picogan and Kitchissakik with those of interviews previously conducted, as I said, with 17 non-Indigenous brush cutters working in different regions of Boreal Quebec and 8 key actors of the sector. The interviews revealed consistent patterns, whether we were talking to Indigenous or non-Indigenous brush cutters. Their perceptions of their working conditions and of labor law was essentially structured around three components: the production-based remuneration model, occupational health and safety, and the geographic dimension of the work. First, Indigenous and non-Indigenous workers have a contradictory relationship to the production-based remuneration model. They would not want to be paid by the hour because they like the freedom and autonomy they associate with production-based pay. I like the freedom it gives me and all that. I'm the one who does my production. I'm the one who makes my pay. That's what I like. There's no one to push me behind my back. The only one I'm going to blame, well, it's me. But this autonomy for both Indigenous and non-Indigenous workers is overdetermined by the price of the areas to be cleared, which is established by the Ministry of Forests. According to the workers, the price does not always reflect the actual work needing to be done. It's just that there are some areas of land that are poorly priced, that's for sure. Because I actually know, when they say it's so many stems per hectare, and I get into it, and it's really dirtier, which means more stems to cut. Well, if I'm the one who gets that dirty area, and the other guys got something easier next to me, that's not fair, but it's part of the game, as they say. Second, occupational health and safety. In labor law, protection against health and safety risks is a responsibility of the employer. In brush cutting, the employer pays for the personal protective equipment, but the responsibility for the use of that equipment and the management of risks in the field is in fact transferred to the workers. Both Indigenous and non-Indigenous workers told us about their individual responsibility to prevent risks they said are inherent to the brush cutting work. Workers had to internalize the responsibility for their own health and safety at work. You know, you make sure you're safe all the time when you're working in the woods, okay? So I don't get hurt for nothing because I did something stupid, because I forgot something. Imagine that. Workers are alone most of the time in a remote forest lands, and they're paid according to their productivity. If, for example, taking off the safety guard on their brush saw allows them to go faster, to cut more, is it possible that these workers, even if they want to ensure their own safety, will take the risk? Oops, I'm bad with the PowerPoint. Third, there is a strong geographical dimension to brush cutting work. I will give you an example. A worker who lives in Picogan or a worker who lives in Amos, a city near the community, has to travel 250 kilometers to get to the camp where he will be housed, and has to travel 80 kilometers each day on unpaved roads to the sites where he works and back. Although Indigenous communities are generally located somewhat close to the areas where brush cutting activities take place, Indigenous workers also raised concerns about the remoteness. These concerns are related to the distance to be traveled, but also to the living conditions in forestry camps. It is a mandatory requirement in the sector to stay in camps. Most of the times, the camp set up fixed schedules, for example, for supper time, which the workers have to comply with. These requirements affect the number of working hours, hence, the pay the workers will get for a day's job. At the camp, they didn't want to push back the dinner schedule. For the brush cutter, he loses 3 hours a day for transportation to and from the site. At the end of the week, it's a big day, maybe a day and a half, that could have been done more just because of the travel. Workers of Kichisakik, however, live in a forested area, closer to where they work. They return home every day. Still, they have to travel almost an hour to and from the brush cutting site. So far, we have seen that Indigenous and non-Indigenous workers share similar concerns because they work in the same trade and are subject to almost identical working conditions. However, differences between the way these two groups perceive their work lie in the singular context in which the Anishinabeg brush cutters I met work. Cooperatives owned by Indigenous interests in which the foremen are community members. Here are my two preliminary findings. What distinguishes Indigenous workers is related to the singularity of the work setting rooted in the workers' community and to the adaptability of the management methods. First, Anishinabeg workers not only share a work environment, but also live together in the same small community. There is a relational proximity between them, often family ties, that go far beyond those created in the work context. It is also necessary to put the participants' answers in a context of socioeconomic inequalities between Indigenous and non-Indigenous people in Quebec, an unemployment rate that is twice as high, significant income gaps, and greater precariousness in living conditions. Indigenous people must deal with the intergenerational traumas caused by colonization and, as Professor Blackett said, its ongoing nature. They face systemic racism in all spheres of their lives, employment being no exception. Anishinabeg workers share the same reality. In this context, the role of the cooperatives extends far beyond carrying out silvicultural work or an economic activity. The fact that these enterprises are owned by Indigenous interests leads to job creation within the community and contributes to redressing socioeconomic inequalities. It's the first time I can receive unemployment payments. Before, I was on Social Security or relied on my husband. That was another source of motivation, to have a pay every 2 weeks and being entitled to unemployment payments during the winters, which are more nicer, by the way. One might think that this is reflected in the choice of the cooperative model. I talked about the role of unions with the Indigenous workers I met. One of them said, "Well, I like a cooperative better. It brings people together. It's more like the way we used to live in the old days. You know, if we didn't help each other, we wouldn't have anything." Second, because Indigenous cooperatives are built around the communities, they are rooted in the local reality and do not only pursue economic development, but also social and even cultural development goals. This shows capacity to adapt the work organization and management methods to the Indigenous setting. For example, in both communities, collective transportation for workers was organized by the cooperatives, in a context where most of the workers had neither a driver's license nor a vehicle. Another example of adaptability to the local reality is the way workers are recruited. Information circulates easily within Indigenous communities, and thus it is easier to reach job seekers quickly when work is available. The adaptation of management methods is also reflected in the relationship between workers and the employer, in terms of discipline, but also in terms of a sense of justice in the way the work is organized and an ease in expressing certain needs. The antagonistic employee-employer relationship that is often present in non-Indigenous contexts was not mentioned in the interviews with Indigenous workers. Anishinabeg workers consider themselves equal to the foremen and to the bosses. They share similar interests and have a common understanding of the constraints they each face. I'm the one who goes to see the guys. but it's rare that I'll tell them, stop fooling around. You know, it's them. I let them go. Of course, we don't want them to take too long on the side. They know what to do too, especially those who have families. They know they have to work to put bread on the table. As I began my field work, I was expecting Anishinabeg workers to talk about their perception of time, about their relationship to the forest as part of their identity, or about some traditional legal principles for conflict resolution. I expected them to have a critical view of their working conditions. Anishinabeg workers do not reject the regulatory framework in which they work, their mode of remuneration and the way it regulates working time, the health and safety obligations, and the conditions related to site remoteness. These conditions are part of their reality, which they embrace. In this respect, their relationship with their working conditions is not different from that of non-Indigenous brush cutters. What distinguishes them, though, is the setting in which they work, which is shaped by the specific conditions in which they live and the cooperative business model they chose. The organization of work built around the community, giving priority to Anishinabeg economic interests, allows for greater flexibility in the work regulation, and also to take into account social and cultural objectives. Would Indigenous workers view their working conditions differently if they were employed by a private company owned by non-Indigenous interests? Most of the workers I met had never worked in such a setting. This would be interesting to test in future studies. Now, what does it imply for labor law that Indigenous cooperatives have implemented their own modes of regulation? Does it mean that labor law is not effective? This is certainly an interesting path to explore in order to better understand the relationship between indigeneity and work. Thank you. Miigwech. That's all.
Great, thank you very much, Béatrice.
Thank you.
So I'll invite our next speaker, and if anyone has any questions or like to make a comment, again, please add that to the chat box and I will put you into the queue. So we have our next presentation. Leah and team, I'll turn it over to you.
Okay, so before I turn it over to Leah and the team to present, before we begin, I want to acknowledge that this conference is hosted by Ryerson in Toronto, and that the land that many of us are on is part of the Dish with One Spoon territory. The Dish with One Spoon is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. Subsequent Indigenous nations and peoples, Europeans and newcomers, are invited into the treaty in the spirit of peace, friendship, and respect. The Dish with One Spoon Treaty reminds us that our welfare is interconnected and that we all share responsibility for each other and for this place, a message that's particularly important in our current times. So now I'm going to pass it to Leah to begin our presentation.
Thanks, Andy. Well, recent scholarship has highlighted the historical and contemporary participation of Indigenous peoples in wage labor in the settler colonial states we know as Canada. Yet less attention has been paid to the gendered contours of the relationship between indigeneity and employment regulation. Addressing this issue, our paper engages Indigenous feminisms and a feminist political economy framework in attempt to apprehend tensions generated by the state's simultaneous regulation of wage labor, perpetuation of settler colonial relations with Indigenous peoples, and the reproduction of Indianness. We do so through a legal case in which Indigenous workers at NIL-TWO, Child and Family Services, or NIL-TWO, a nonprofit child welfare organization formed by several First Nations to serve Indigenous clients on Vancouver Island, attempted to unionize. We analyzed the case of NL-TWO versus the BC Government and Service Employees Union, or the BCGEU, as it moved through the legal system from 2006 until 2010. The arc of the case is this. On the 23rd of March, 2006, the BCGEU applied for union certification to the BC Labour Relations Board to represent non-supervisory employees at NIL-2O. The employer contested this application on the basis that the agency's operations fall within federal jurisdiction and hence are governed by the Canada Labour Code. NIL-2O contended that its activities, the provision of culturally specific Indigenous child and family welfare services, meant that it falls within federal jurisdictions as these activities touch a key concept, the core of Indianness. The core of Indianness is a contested concept referring to federal jurisdiction over Indians and lands reserved for Indians, I quote, under Section 9124 of Canada's Constitution Act of 1867, which emerged in case law around land rights, hunting, fishing, and harvesting rights, and labor relations, among other things. A 3-member panel of the BCLRB denied NIL-2O's request for reconsideration and held that its labor relations, like those of other service providers in British Columbia, are provincial. This denial set in motion a legal battle over the jurisdiction of the wage labor performed in Indigenous Child and Family Service Organization that reached the Supreme Court of Canada, which ultimately affirmed that provincial regulation of NIL-2O labor relations, the provincial regulation of NIL-2O's labor relations, setting an important precedent for determining the jurisdiction of labor relations in Indigenous social services. In the remainder of our time, I'm going to first sketch the theoretical framework upon which we draw in our paper, and next Adam and Olena will talk about the 3 stages in the case, and Veldon will then conclude by considering some of the issues raised by developments seeming to diverge from the Supreme Court's decision in L2O. Before proceeding, though, I want to emphasize, and we do this in our paper, but we don't have time here, that our focus in this case is motivated partly by the knowledge that child welfare is a contested site of decolonizing struggle, in part because of the long history of state targeting of Indigenous childcare. So in critiquing the settler colonial regulation of Indigenous identity in Canada, our framework looks through the lenses of Indigenous feminisms and feminist political economy scholarship on social reproduction. In Canada, the notion of Indianness has evolved conceptually as both a tool and an articulation of longstanding processes of dispossession, including settler colonial appropriations of Indigenous lands, resources, and labors, and settler governance over Indigenous identities and impediments to Indigenous modes of life. At the same time, as my colleague Veldon argues, there is a two-sidedness to this Indianness. While Indian identity is regulated by the settler colonial state through the Indian Act, it is simultaneously and contradictorily, given the Act's assimilatory intent, a source of both identity protection and material protection, that is, of land and livelihoods, particularly those with Indian status. Informed by this contradiction, we assert that both whose labor and what labor is included in and excluded from the core of Indianness matters. Our analysis of the case identifies a double exclusion of feminized Indigenous labor from the core of Indianness. First, the core of Indianness has been read through an historically constructed tension between capitalist wage labor and subsistence Indigenous labor that results in an exclusion of the latter from the former. And second, the labor of social reproduction that is feminized as it is in the Western capitalist political economies like Canada is excluded from the types of labor encompassed by the core of Indianness. Consequently, this feminized labor is either conflated with a universalized approach to childcare or treated as culturally specific, as a culturally specific approach to care in line with Canadian liberal multiculturalism. This second exclusion is heightened by the fact that in NIL-2O case, social reproductive labor is performed in exchange for wages. As Kim Anderson and Gina Starblanket both argue, settler colonialism reproduces an unchanging pre-contact version of indigeneity wherein being Indigenous requires adhering to particular cultural criteria. Not only does this version of indigeneity deny the generality of change in any community or mode of life, it obscures the particular changes wrought by settler colonialism. In the case of labor, the core of Indianness has been narrowed to effectively position it outside wage labor and market exchange, our first exclusion. Furthermore, the settler colonial lens typically only includes land-based and indeed masculinist labors, such as hunting and trapping, as being within the scope of Indigenous labors, qua Indianness. The feminized labor of social reproduction, as well as of subsistence activities that we don't actually take up in our paper, like sewing and beadwork and such, are obscured through a narrow and static formulation of Indian labor. Indeed, courts have cast traditional modes of Indigenous care as frozen in time. Contradictorily, these modes of care have been defined outside of what it means to be Indian. Now, Olena and Adam are going to talk through the case.
Okay, so we now turn to our analysis of the three stages of the NIL2O case as it moved from the BC Supreme Court to the BC Court of Appeal and then to the Supreme Court of Canada. We've conceptualized these stages based on the legal reasoning used by the judges in their various decisions as pre-exclusion, exclusion, and formal exclusion. So we'll briefly cover the specifics of each of these decisions. As mentioned previously, the BC LRB denied NIL2O's application for judicial review over its labor relations being federally regulated. NIL2O then appealed to the BC Supreme Court. In this pre-exclusion decision, the BC Supreme Court, however, did find NIL2O's labor relations to be federally regulated. The court applied a definition of the core of Indianness encompassing the paid labor of social reproduction. The court argued that NIL2O provides child and family services to First Nations people in a particularly Indigenous manner. Justice Cullen at the BC Supreme Court drew upon several previous decisions involving labor relations in Indigenous education, social services, and addictions treatment to argue that child welfare is integral to the reproduction of Indianness and thus a matter of federal responsibility. NIL2O believed that the regulation of its labor relations should fall within the federal jurisdiction because of federal funding and involvement in the delegation of services and the scope of federal responsibility to Indigenous peoples under Section 91-24 of the Constitution Act 1867. As NIL2O later detailed in its vacuum to the Supreme Court of Canada, the organization explicitly understood federal jurisdiction over child and family welfare services and the delegation which flows therefrom as part of the path to self-determination. Next, the union appealed to the BC Court of Appeal. The justices there disagreed with the reasoning set out in the previous decision and argued that NIL2O's labor relations were in fact provincially regulated. Justice Groberman argued that the practical activities, child and family services, of NIL2O did not mean that its labor relations touched the core of Indianness, and questioned whether the content of NIL2O's services meant its labor relations were a matter of federal jurisdiction. The BC Court of Appeal nevertheless considered the most relevant issue to be establishing that child and family services are generically a matter of provincial legislative authority. In contrast to the BC Supreme Court, Justice Groberman reasoned that because child and family services generally are a provincial matter, the formal content through which these services are delivered should not bear on their jurisdiction. Yet, as the union recognized, this reasoning was only partial. By leaving open the possibility that federal involvement in an Indigenous enterprise might involve jurisdiction over labor relations, the Court of Appeal left open the possibility of further contestation on this issue. The BC Court of Appeal thus opened a pathway through which to narrow the core of Indianness and exclude the paid labors of social reproduction.
Finally, in the third stage of the NIL2O case, in 2010, the Supreme Court of Canada upheld the ruling of the BC Court of Appeal and maintained that indeed NIL2O is a provincial undertaking, making its labor relations provincially regulated. This decision formally excluded Indigenous social services from federal jurisdiction and the core of Indianness. In making this decision, the Supreme Court of Canada relied on the two-step test established in the case of 4B in 1980 and since used in jurisprudence to determine the status of a federal undertaking in relation to jurisdiction over labor relations in First Nations private industrial enterprises. The first step of the test is functional and looks to whether the functions of the undertaking, service, or business make it a federal one, and thereby place its labor relations under federal jurisdiction. If the functional test is inconclusive, then the second step determines if and how provincial legislation over labor relations might impair the core of federal power or the core of Indianness. By extending the application of the strict functional test to NIL 2.0, a public child and family welfare agency, and conclusively determining it to be a provincial undertaking, the court formally excluded Indigenous social services from federal jurisdiction, previously interpreted to be a matter of federal legislative authority and responsibility under Section 9124 in relation to, quote, Indians and lands reserved for the Indians, end quote. The Supreme Court of Canada decision rested on the equalizing multiculturalism argument by leveling the special status of Indigenous people with other cultural groups in Canada. The court argued, quote, the fact that NIL 2.0 employs Indians and works for the welfare of Indian children in a culturally sensitive way that seeks to enhance Aboriginal identity and preserve Aboriginal values does not alter the essential function, end quote, i.e. the provision of child and family services. In asserting that NIL 2.0's provision of services to Indigenous children is essentially no different from the provision of services to any children in Canada, and thus a provincial matter, the Supreme Court of Canada obfuscated the history of settler colonial violence and dismissed the paid work of Indigenous social reproduction as a step towards self-determination. The court did so by celebrating the provincial delivery of culturally specific social services as part of promoting a model of flexible and cooperative federalism. Couched in terms of liberal recognition, the decision ironically misrecognized the fact that First Nations social service agencies have their genesis in the failure of generic programs offered by the provinces as applied to First Nations children and families. In removing Indigenous child and family welfare services as well as their labor relations from the legal meaning of Indianness and accordingly from federal jurisdiction, the Supreme Court of Canada decision mitigated the historical and material significance of Section 9124 and set a major precedent for the legal understanding of Indigenous labor in Canadian constitutional law.
So, in receiving royal assent in 2019, Bill C-92, an act respecting First Nations, Inuit, and Métis children, youth, and families, the statute provides a potential space to empower Indigenous peoples to reclaim jurisdiction in this area and ensure the rights of children are affirmed. Following our analysis, the new act appears to reintroduce some of the legal reasoning adopted in the pre-exclusion phase of the NIL 2.0 case. In introducing this legislation, the federal government has affirmed the right to self-determination and self-government of Indigenous people includes child and family services within the ambit of Section 35 Aboriginal Rights of the Constitution Act 1982. However, much of this new legislation remains unclear, particularly as it relates to issues concerning the labors of social reproduction discussed in our article. The new legislation positions the devolution of child and family services to Indigenous peoples as a matter of Aboriginal rights rather than as emanating from the federal government's responsibilities to Indigenous peoples under Section 9124 of the Constitution Act 1867. While on the surface this approach might seem politically more palatable, it risks moving in the direction of circumventing Section 9124 and thereby excusing the federal government from providing ongoing funding alongside with delegation. Furthermore, the dismissal of Section 9124, or what is the core of Indianness, could be read as part of a larger trend of subsuming Indigenous rights under, quote, difference and multiculturalism in Canada. The court's reliance on multiculturalism and the interpretation of Indigenous modes of care as merely cultural on par with other minorities was central to the double exclusion of Indigenous women's labors from the core of Indianness in the case of NIL20. As NIL20 argued, Aboriginal rights have a special legal and constitutional status in Canada, as well as attached federal responsibility, which thereby distinguishes Indigenous self-governments in matters of child and family welfare from merely multiculturalism more broadly. As we have suggested, relegating Indianness to the cultural realm neglects the distinct modes of life that Indigenous labors reproduce. We should ask then, what is the legal relationship between the judicial precedent set in NIL20 and now the new Act? It is scarcely an exaggeration to suggest that the NIL20 decision and the 2019 legislation are fundamentally at odds, which has particular relevance for labor relations in Indigenous social services, where federal paramountcy, or federal responsibility in the case of delegation to Indigenous peoples, is established. Legislative authority over labor relations necessarily follows. This clear line is why the legal battle throughout NIL20 hinged on determining which Indigenous practices fell within Section 9124 and were therefore matters of federal authority via the core of Indianness. The Supreme Court of Canada's use of the narrow reading of the core formally excluded wage labor of Indigenous child and family services, and thus Indigenous social reproduction more broadly, and effectively dispossessed both Indigenous service providers and Indigenous workers from exercising constitutional rights as Aboriginal peoples while engaged in social service provision. Thank you.
Great, thank you very much. So let's move on to our final presenter, Kevin. I turn it over to you for your 15 minutes, and then we'll have some time for questions and comments.
Okay.
It's down there. Is that it?
Yep.
Ben, did you press share?
Yep.
Click on that then share. Yeah. That should say it now.
Okay, so my name's Kevin Moore. I'm an Indigenous Pre-Doc Fellowship from RMIT, and my mob or my clan are Grinji. I'd like to acknowledge the people whose land we're doing this conference on. And why do we do acknowledgement? For me, we do acknowledgement for respect, and we to show that we come in peace, and we're not. It's not an act of war. So, yeah. So, full respect. The aim of this study is to capture the range of voices emerging out of the Victorian Treaty, and my objective at the moment is to maintain true cultural respect and accurate accounts in observing voice and identity in the Victorian Treaty. In the Australian context, the Commonwealth of, there's no treaty in Australia, and we're the only Commonwealth country in the world that doesn't have a treaty, and the state of Victoria has started the process in meaningful dialogue with its Indigenous people of Victoria or Territory. And if you have a look at this map, you can see all those different colours. They're all different clans or tribes or mobs, as we call them. And you can see that spread out all through Australia. And if you have a look at a map of Australia in a colonist context, you'll see 7 states or territories. I'm a Grinji man. I'm a descendant of over 2,500 generations living on Australian continent from my mother's side. We're desert people, so if you ever come to Australia, there's desert people, there's saltwater people, and we're well known for our skills as horsemen and cattlemen. And we're very famous for walking off in protest over stolen wages and our land. And so we walked off in 1967. An elder called Vincent Langary decided that we weren't getting a fair deal, and we walked off. And in 1975, the then Prime Minister Gough Whitlam handed back our land in a gesture of pouring sand through Vincent Langary's hands. It was the longest protest in Australia, so that's something to be proud of. And each year we celebrate that event. So in the latter part of the century, we're the only people in Australia that have to prove that we're Aboriginal, and there's a three-part thing there that says that, you know, our descent, who we are, and our associations to those communities. Indigenous standpoint, everything I'm doing, the last part I just spoke about, that is Indigenous standpoint to me. It's about my perspectives, my mob's perspectives. It's self-determination. It was born out of struggle from colonisation. Aboriginal people have had continued to have this prior to colonisation. We had our own ways of knowing, being and doing. We knew how to fish, we knew how to gather, storytelling, and we have our own ways of methods, as in yarning, and that's an oral way of doing things, or conversation. So my identity, sorry, I've already had this one. Okay, so moving into colonisation, we've had colonisation for, you know, since the inception. We had Captain Cook come in and take the land against his orders. He was supposed to come in and make a treaty if there was natives on the land, which he ignored, which was in direct conflict to what he was told to do. And from that very first time, we've had a struggle in Australia, and we've had all these problems that have just continued. And one of them is the assimilation policy. Stolen generation. It was a residential school, I think you might call it over there. And the assimilation is actually a white Australian policy. It's an actual policy. And then they had the Protection Act in 1909 to the 70s. And all this was to do was to control money, restrict movement, remove children from their families, especially the ones that were half caste, which meant that they weren't full blood, and supervised control. So in other words, it was almost like an apartheid within Australia, but less publicised like we would in South Africa. And a lot of this leads on to transgeneration trauma. My mother was stolen generation, her brothers and sisters were stolen generation, and they've always had troubles in their lives with identity sometimes, and connection, all that sort of stuff. We're pretty lucky. We've kept those connections with our families, and you know, I know who I am and I know where I come from. Historically, so we've got colonisation again, which led into terra nullius, which I spoke about earlier. An elder called terra nullius. I'll just go through terra nullius. Terra nullius means vacant land. There's empty land. There's no one there. This was what Captain Cook put his premise on. He thought that's not enough people to make a treaty, hence there was no treaty made. So an elder, Torres Strait Islander elder called Eddie Koiki Mabo, he said, "This is my land," and he challenged terra nullius in court, and he actually won, and which disproved terra nullius ever existed, and so they were given back their land. So we've had major government policies here that have failed. One of them's been closing the gap. This Closing the Gap has been in for something like 10 years, and it is getting wider. It's not getting any smaller. And this is to do with a whole range of things, but it's still a failed government implementation. In 1991, we had the Royal Commission into Aboriginal Deaths in Custody. And since then, we've had, since 1991, we've had 430 odd Aboriginal people dying in custody to this day. So even the Royal Commission hasn't worked, or these systems haven't worked for Aboriginal people here in Australia. Which leads into the Black Lives Do Matter. You know, we've been fighting since colonisation, and I think it's coming to fruition now with all the movements happening throughout the world. Rose argues the underlying premise of colonisation was to disturb social and family structures, dismantle language and culture structures, disturb life and being, to diminish enterprise. And all that is, we always are answering to somebody. We don't have our own self-determination. And when we do, we're always answering to a white body, which means that we don't have our own self-determination. So I just thought I'd throw that slide in. Some of the key themes that are coming out of this, this treaty in Victoria is self-determination. And as you can see, you know, having autonomy for one's businesses, decisions and policies concerning and affect Aboriginal people. Sovereignty was never ceded. We've never ceded sovereignty. And that might be a bit of contention within this treaty, because although the Victorian government is agreeing with treaty, they're not coming to the party with sovereignty. So we've still got a ways to go off that. In the Constitution, where Australia, you know, the freedom of individuals in Australia is totally different, juxtaposed to the US, and Aboriginal people aren't even in the Constitution of Australia. Reconciliation, we've just had Reconciliation Week. We have Reconciliation Week here in Australia. It's to help the broader Australian community get to know Aboriginal people, get to know an Aboriginal person. This was implemented in 1987, and it was tried to move away from talk of treaty, which has in some ways worked, because it splits communities. When you talk about reconciliation, you talk about treaty, people are like, yep, I want reconciliation, and some people want treaty. I just thought I would show you this is the Victorian map. So, and if you can see there's a border up the top, and it comes down, waving, it comes into the sea. The next part of that is is New South Wales. As you can see, our map spills over into those territories. So it's not a true indication of how our groups or clans live within those areas. Indigenous and non-Indigenous scholars argue three conditions set out in the contemporary international human rights concerning Indigenous peoples. I'm not going to read all that out. Please, if you can have a look in your own leisure, but you know, it recognises Indigenous people and self-governing, all the things I just spoke about, negotiation with Indigenous peoples with stated procedure, and a treaty involves inclusion. So that's a big one. So treaty consultation. So we've had consultation, which started in 2016. So the Victorian government it does recognise sovereignty, was never ceded, but they're not saying that we can have sovereignty. They want us to advance towards self-determination. That's because of all the failed programs that have been put in, like Closing the Gap. We've had education, health, all these kinds of things that just aren't working. So they've come to the conclusion that maybe it is an idea that Aboriginal people have self-determination, and and even self-govern. So this brought the Victorian government to the table through some bipartisan measures. And as you can see, consultation with the community started in 2016. The Victorian Treaty Advance Commission that was set up to actually put in frameworks for this treaty. And then we have the advancing the bill in 2018, which is an actual bill, it's a treaty bill in Victoria. And now we have the Aboriginal representative body who's taken over from the Victorian Treaty Advance Commission, because they're now no longer needed because we've had the election. This slide here just shows you that there's 38 nations prior to colonisation in now what is Victoria. There are 28 seats. 11 of those seats are reserved. So that leaves 17 seats for this election. So you've got 27 nations fighting for those seats. So there's conflict within these nations already. And if you go to some of those community consultations, you'll see that. Only traditional owners are now traditional owners is somebody that lives in Victoria, and they're a native, as you can say, or from Victoria, and they're the only ones that can stand for election. Pan-Aboriginal is me. I'm not from Victoria. I'm from up north, up towards Darwin. If you have a look at the map, you'll see up north, I'm up that way. So Pan-Aboriginal is somebody that's living in Victoria, but doesn't come from Victoria as an Indigenous person. So we had the right to vote. They gave us the right to vote. I can tell you now, if it was on my country, it was on Kalagurinji land, it wouldn't have happened, because we would only have our own people voting. So, but as you can see, there's 32,000 Aboriginals living in Victoria, and you know, I would say a good percentage of that are Pan-Aboriginal. So the voting age was dropped down to 16. Usually here it's 18. You're eligible to vote, and polling included ballot and electronic mediums, which has never happened here as well. So we're kind of crash test dummies for the next election in Australia for the wider community. My research method is going to be a qualitative one. It's going to be, as you can see, interviews, participation, observing, individual groups and stakeholders. So I'll be, because I'm eligible to vote, I'm into the community, I'll be observing, I'll be doing interviews. I do know some of the representatives, I know some of the grassroots representatives, so I've already got an in, and it kind of helps that I'm not from Victoria, if that makes sense, because I haven't got any allegiance to one group or another. This is some of the theoretical lens that I'll be using. Voice equals identity, catch-22, so they go hand in hand within this treaty process. And as you can see, voice has multiple mechanisms, but, and I'll be using more than I've put up here, but some of the stuff I would look at is direct and indirect voice. You'll have direct voice where you have somebody talking directly to the candidates and stuff, and then you'll have representatives talking to your elected leaders. And you have different participation access points, such as voting and consultation at multiple levels, as in, you know, with community consultation and stuff like that. And then we've got social identity. You have social identity, and I spoke about this earlier, which it kind of makes sense. We have 38 groups within Victoria, and you can understand that you've got in-groups and out-groups. You've got groups that have been voted in, and you've got groups that are seen as the out-group and aren't being involved within the actual treaty process, which causes conflict, and you know, it can be very fiery at times. Then we have, and whose voice are we listening to? You know, we've got in-group opposed, you know, and they're stereotyping the out-group that are negative. So we've got positive and negative concepts there. And this was just discussion, and I thought I'd throw that up there, but Non Gujin, thank you very much.
Great. Thank you very much, everyone, all our presenters, for your scholarship and very detailed and provocative discussions. So I already have some comments in the queue. The first one is, I will turn it over to Martin. Martin has indicated that he would like to make a comment to Adelle. So Martin, if you want to unmute yourself and proceed with your comment.
Thank you so much, Chair, and thank you to all the panelists. I mean, I was just amazed by the different levels of analysis and this very, very interesting and fascinating panel, which is really a very timely contribution. And so while I wanted to thank Adelle, I mean, now since I listened to everybody, I wanted to thank everybody. But particular with regard to Adelle's, I think, thank you so much for unearthing these gems from the ILO's history. I mean, we know that there's a lot that we have to rediscover and look at. No? Just in brackets, I work in the ILO on legal issues, and I'm focusing on indigenous people's issues right now as well. So that's why I think we're thinking that this debate becomes very timely, since this is about decolonizing labor law. I think also the very last presentation from Kevin Moore shows that this process of decolonizing and reforming labor law, so it does a better job with regard to work performed by indigenous women and men, irrespective of the work relationship, in an employment relationship, outside of an employment relationship. Hand in hand with that, it's important that we look into issues of self-determination, governance, and broader participation. And this is actually the element that is often missing, and that the ILO in its trajectory over almost 100 years dealing with these issues, culminating in Convention 169 in 1989, has been trying to advance. But I think it's well known that in 1989, the ILO Convention fell short of recognizing fully the right of self-determination. And when this process goes on in the UN, we are going into a non-binding declaration adopted by the General Assembly, which acknowledges self-determination more forcefully, but at the same time also brings in a lot of caveats and reservations and restrictions. The next point that I wanted to make, and maybe that's also a little bit the question that I would have to Adelle, how we can better bring together the legal approaches with economic approaches, no? Because traditionally the ILO, we would hear from the unions, indigenous people's rights are human rights, are labor rights, they need to be protected, access to justice, access to remedy, that is absolutely true. From the employers, the private sector, we hear that indigenous people's rights are also a tool for governments. So if you want to regulate consultation, participation, that this is also good if you want for business. So we have that business case very strongly. So in Canada is certainly an example where you have a lot of support also from the government for indigenous business. In the COVID context, we have seen that as well. Canada and Australia were one of the quickest announcing targeted measure to support indigenous businesses in this time of COVID. But at the same time, there is also much more need to regulate more the issues of consultation participation, and the employers make a very strong case in terms of creating a favorable and secure, legally secure investment environment. No? This is the idea of prior consultation as favoring investment that hence will then also generate prosperity, employment, and decent work for everybody. So these are different visions, but in the ILO we bring them together. But how we can bring these things together better in the ILO? So that would be really the I would look advice from the panelists, and maybe starting with Adelle from that. And I completely agree that since the Philadelphia Declaration, we haven't spelled out race specifically. Not in 1998, not in 2008 with our landmark declaration, and also not in the latest Centennial Declaration, where we have a focus on discrimination in general, but then focus on gender equality and on disability, more specifically. But that race and ethnicity is missing, and I think it's symptomatic, and I would agree with that. We know that labor markets there is a segmentation in the labor market that is ethnic, that is racial. If we look at the data that we have at the global, at the regional level, and this is also the subject of the following session, where we have a couple of ILO people presenting a report that we have launched last year based on existing labor market data. We see that this is very clearly a problem, and it's not by accident. Let me put it like this. But I think that this macro level, regional and global data on employment of indigenous peoples needs to be complemented by deep dives. And I think I was very much impressed by the work presented by Béatrice Venne, really trying to understand what is happening at that sort of grassroots level, when it comes down to different types of work arrangements and why indigenous peoples favor the one or the other, and so on. Because with this, we have to explain why indigenous peoples are much more self-employed than employed, and all of the things, and this needs to help shape also the programs and the policies that to create employment that is actually respectful of indigenous people's rights. So anyway, I'll stop here and back to you, Chair, and through the comments, maybe replies later.
Okay, great. So I guess I'll turn it over to Adelle since you were first addressed, and then if any of the panelists would like to also speak to Martin's comment.
Yeah, so thanks very much for the comment. I'll be brief. There is, of course, a balance and a reconciliation that is necessary between a human rights approach and a business case. But one of the things that the ILO has that is remarkable and underutilized is that its raison d'etre is to improve the conditions for workers, right? That's its starting point. And its framework in the Constitution and then in the constitutional annex, that is the Declaration of Philadelphia, gives it a remarkable capacity to have a particular lens through which it has tripartite dialogue. So it's not just tripartism and, well, we've got a business case and we've got whatnot. There's a focus, and it is social justice. So this should frame the boundaries of the interactions. And in a matter like this, the approach to Indigenous rights is one that understands the why, right? And puts the why of the engagement first and foremost. So one may have a discussion about how best to do that, but we're never meant to be questioning that, well, I would say self-determination. We could have a longer discussion about how the ILO's committee of experts could more effectively understand its own reading of instruments in a particular time in relation to subsequent developments in international law, to be able to harmonize our international law landscape in keeping with the ILO's constitutional mandate. That is a longer discussion, but I don't think the ILO should be as stuck as it somehow seems to be around Convention 169. And finally, but really this is an answer to all as well, representation. The ILO, shockingly, has not done a good job on representing the very communities that are on the margins and that are historically excluded. I would love to see data on, for example, how many African descendants of slavery there are working at the ILO right now. Right now. I'd like to see the same data on how many Indigenous people are working at the ILO right now. We have consultative processes in the ILO. There's deep and important thinking about the nature of tripartism. But what about the office itself? Right? If one wants to actually speak to these issues, one has to have better processes for inclusion within the very formulation of the policies that move forward. So, yeah, thanks.
Could I add a tiny point to what Adelle said?
Yes, absolutely. I was just going to invite other panelists. So Leah, please jump in.
Having done a little bit of work myself on the ILO, but not as recently as Adelle. I mean, I would have answered in a similar way, but I also might have emphasized, especially around office representation, the question of representation, not just in the office, but also representation, thinking about the bounds of tripartism and how they might be properly enlarged to allow both representation within the office and through the funding arrangements that it involves, and also representation in the body itself. But I would also add that the issue of frozen in time that we bring up a little bit we brought up a little bit in our presentation is something that I think both those in the office and those thinking about the future of conventions, recommendations, protocols, and such need to take very seriously. On the one hand, that we need to think about these relations as not frozen in time, but we very much need to think carefully about erasing, and I mean, Adelle sort of started like this, but erasing past injustices, so that even the sort of commentary about we don't understand why Indigenous people aren't engaged more in self-employment, which is, I think, a veritable question, of course, but even starting with that question as opposed to sort of a historically rooted understanding of modes of labor, subsistence and otherwise, needs to take into account those historical relations that have preceded us in order for it to actually be a deep rethinking of the sort that a lot of us support.
Okay, wonderful. Any of the other panelists like to comment to this question before we move on? There's 2 more questions in the queue. Okay, so I'll move to the second question or comment that was raised by Yushnish. And this question is posed to the entire panel. And the question is it organizational form, cooperative, or ownership, Indigenous, that has a greater influence on labor relations?
I think that question was raised after my presentation, so I might begin by answering. From what I've seen, it's really both of the, the cooperative model allows for the property of the community and of the economic interest by the members of the community. So it's really the conjunction of both, because it also allows to keep the interest in the community. For example, as opposed to a private enterprise that could, just be on bankrupt, for example, or I don't know. Co-ops can be on bankrupt as well, but it creates a sort of stability and a place where every member of the community can become a member of the co-ops and then gain, have access or share the property of the economic interest. So I would say both.
Any other panelists like to speak to this question? Okay, I'll move to our final question in the queue, which is from Fareed to Professor Blackett. In what ways, if any, do you see the ILO playing additional roles in exposing sediments of colonial thinking in employment standards around the globe towards the goal of addressing continued racial discrimination in employment, particularly in the West?
Thank you very much, Fareed. That's an extremely important question, and I won't pretend to offer a comprehensive response. Simply acknowledge the extent to which calling on the ILO to play that role is crucial in this moment. I think it's been missed. One of the striking features in our turn to talking about diversity, rather than talking about historical forms of injustice, is that we then enter into an analysis, and this came up, I think, really effectively in the team presentation that Leah Vosko led, is we lose sight of the ways in which the injustices require a deeper form of engagement. We also lose sight of how we can't just cherry pick. Right? We can't just choose to address one form of injustice and pat ourselves on the back and then move away. And so the ILO has a responsibility as the premier international organization on labor to offer a deeper, more thorough analysis, an analysis that sees the interconnections and that offers guidance. The ILO, of course, cannot stand alone. And much of the framing that the ILO built out of the Declaration of Philadelphia was meant also to infuse other international organizations. And the kind of trade system that we would have had that the ILO and Wilfred Jenks were pushing for would have embraced a different vision of the relationship between employment and trade, for example. So we need to be thinking comprehensively. We can't be myopic about the role of the ILO in a deeply neoliberalizing world. However, the ILO's leadership on thinking through the interconnections is critical. In my presentation, I highlighted the COVID-19 moment. I think it is a tremendous opportunity to think about what it looks like to focus on essential but previously invisible workers and to acknowledge the role that they play in our society, and then acknowledge the disproportionate burden. This is a breakthrough moment. I don't understand how it is that the ILO has remained so silent about the racial dimensions and why it's essential for us to be addressing them. So there are starting points. This is not a comprehensive answer about how, but I do think being alive to the moment and really listening to the people who are most concerned is one way through which the ILO can do better. But it has to be willing to listen, and that listening means it has to be willing to invite people in to talk about difficult topics.
Okay, wonderful. I'm mindful that we're just past 10 o'clock. So I think that this brings us to a close. I want to again extend a sincere thanks to all the panelists for their work and their scholarship and presenting these very important topics. So thank you again to all the speakers and those attending. Thank you for joining us. And I look forward to seeing everyone virtually throughout the rest of this conference. Thanks to Shruti also for the technical assistance.
Thank you, everyone.